SwayamPrabha. Digital India. Educated India.
Welcome viewers, this is Dr. Ashwini Sival. I am from Faculty of Law, University of Delhi, and I am with you to discuss a very important topic called Electronic Revolution, Dilemmas of Legal Control and Civil Liberties. This is topic number 14 of the series called Law, Science and Technology. My dear viewers, in this series called Law, Science and Technology, we have been discussing excellent topics on different kinds of issues on the intersection of law, science and technology. This is one important topic on electronic revolution and dilemmas of legal control and civil liberties. This topic is of utmost importance, dear viewers, because it does not only involve the laws which are technological in nature or which are scientific laws. It rather involves even those laws like Constitution of India and other laws which empower the civil liberties in the society. And I hope everyone understands how important our civil liberties are, our freedoms to speech, our freedom of expression, our dignity, our liberty, our right to trade, our right to profess any religion. All these civil liberties in the age of electronic revolution leads to dilemmas of legal control, and that is why I have deliberately articulated and named this topic as dilemmas of legal control, because when it comes to civil liberties in the age of electronic revolution, the legal control or the safeguards or the framework pertaining to legal control is quite complex, and it is not straightforward. There are lot many laws which will get involved or which need to be discussed and involved to understand actually the framework on the legal control of electronic revolution and ultimately which regulates the civil liberties or upholds the civil liberties. Well, in the surveillance state or in the state where everything is monitored so closely by the states or by the nation states, it is becoming all the more important to understand our civil liberties as well as the legal controls and their constitutionality or their efficacy. The states in these days, because of the electronic revolution, has taken the shape of you may say draconian states, or they have taken the shape of surveillance states, where our information, where our privacy, where our personal data, where our property, where our person, where our intellect, everything is at jeopardy or is at risk. So to understand it, to understand the legal control, to understand the legal metrics on this particular aspect becomes really significant and relevant for the law students as well as for the general populace. So my dear viewers, with this brief note or this brief background, I would like to start my presentation on this topic. As I said that surveillance state ultimately it begets a society that at times breeds conformity and obedience and submission, which is not good. The obedience, submission and conformity to a nation state, to a sovereign state is required, but it must not be the unfettered submission, or it must not be the unfettered obedience, or it must not be the absolute conformity, because whenever the state is so powerful, or whenever the state is so predominant on the civilians or on the civil society, the society collapses. And it has been seen in many nations that the nations or the sovereign countries which have imposed such rules or regulations on their citizens, on their civil societies, which are very difficult to follow, which are very difficult to abide, or which are not easily obligated, then it leads to collapse at times. So such an anarchic society makes sure that only the powerful in such societies prosper, and the the normal beings or the normal civil society in such situations remains crippled or severely crippled, because their rights and their voices are not heard, their voices or their issues are not heard. They do not get their rights or the possibility of their rights to be enforced in such a society, because they are not wealthy enough to assert their rights. So with this premise at hand, it is important to discuss the civil liberties vis-a-vis the electronic revolution. Well, viewers, in this series we have been talking about lot many technological revolutions, and one is electronic revolution. But when it comes to civil liberties versus electronic revolution, the main component which it hampers or which it impedes is your liberty, is your freedom, is your protection, and many other things. But identity, protection, and your freedom remains at risk always in such a situation or in such a society. So the three core human values which might get affected or which are getting affected in the electronic age are identity, freedom, and protection. And there are many other important human values that might get affected, or that the electronic revolution might jeopardize, like equality, democratic deliberation, justice, tolerance, your privacy, your decisional privacy, or your bodily autonomy, and so on and so forth. These are just illustrative. There may be many other things which might get compromised. So the electronic revolution, or the state and both these stakeholders, the users of the electronic revolution or its advantages, they must promote a society in which privacy is safeguarded as a fundamental human right, and your creativity and your dissent, exploration, your opinion is regarded and respected. So to strike a balance in a state, promoting all these values taken together is chimerical, or is something which is not easy to achieve or attain. But there are certain laws in place, there are certain legal control mechanisms in place which might help to to address this dilemma, or to address a balance, or to strike a balance between the civil liberties on the one hand and the advantages or disadvantages of the electronic revolution on the other hand. So this electronic revolution is studied in consonance with the civil liberties. So the electronic revolution versus civil liberties, they need to be understood in consonance with each other, or they need to be studied in consonance with each other. Whether the electronic revolution is a boon or bane for democracy will depend largely on how the technologies are designed to strengthen the civil liberties and rights of citizens to participate in administrative making or rule making. Well, it has been seen that these days democracies are functioning in a very different way. They do not usually involve the citizenry into their decision making, and the electronic revolution has empowered the governments, basically or the regimes in the different nation states, to perhaps not let the civil society to get involved into the decision making or into the rule making. So most of the times it is emphasized, or the thrust is given on the point that whenever the rule making takes place, or any administrative decision is taken, or any governance decision is taken, the electronic revolution should be used. But as I said, that electronic revolution is a boon or a bane. It depends largely on the way it is used, or in the way it is designed to strengthen the civil society. Participation in rule making is one of the most fundamental civil right, or you may say most fundamental requirement, but usually it is not seen, or it is seen that the rule making is a unilateral process. It is no more a multilateral, or it is no more a involving or inclusive process. And the technological systems for information and communication management, they are used for, or they are designed for not allowing the citizens to raise their concerns and to get their concerns incorporated into rule making or into the decision making, as well as into the governance models of these days, or of the governments of these days. Well, public technology systems will change our political culture in every area of government without attention to how they are designed. These systems may further attenuate representative institutions and weaken the right of participation. So far as electronic revolution is concerned, and the public technology systems are concerned, it has been noted and observed, when it comes to public technology systems, it is about governance or e-governance, electronic governance, which is used for sometimes rendering or extending some benefits to the beneficiaries, or sometimes for governing the nation states. So these public technology systems, they are weakening the right of participation of the civil society in the absence of the regulations which upholds the constitutional tenets or constitutional values, in the absence of tenets which uphold the fundamental rights or civil liberties of the people. It is also important to note that in the surveillance state, civil liberties are at a great jeopardy or at a great risk, but sometimes it can be helpful for the state or for the particular nation state in order to maintain law and order, in order to smoothly function and govern the society. But unconstrained surveillance, especially of activities which threatens the cognitive revolution, that cuts a freedom of the mind, and that our political institutions presuppose, is dangerous, right. So unconstrained surveillance is dangerous. Surveillance to the level or to the extent of keeping an eye on the unscrupulous entities, keeping an eye on the terrorist activities, keeping an eye on the law and order in the nation state is fine, but when it comes to uncontrolled or unconstrained surveillance on the citizens, or on activities which cut their cognitive freedom, is dangerous, is not required, or it should not be there. Therefore, surveillance must be constrained by legal and social rules. But what has been seen, that the surveillance across different jurisdictions in the world is not is not governed by any rules, or if at all it is governed by some rules, the rules are not followed appropriately, or in the guise of some reasonable restrictions, or in the guise of some curtailment on the freedom, etc. It is usually the surveillance is uncontrolled or unfettered. So the technological, economic and geopolitical changes of last few years have whittled away both formally on their substance and in practice the rules pertaining to governing the surveillance, and which is a matter of great concern, and law is not able to cope up to such electronic surveillance, because of the advent of some advanced modes of surveillance, like small insect sized drones are being made and are being deployed for surveilling people, for surveilling politicians and very important and high echelons of the government and of the society. So these kinds of activities are going uncontrolled or unchecked. Well, but thus recognizing harms of surveillance and crafting our laws accordingly, we can obtain many of its benefits without sacrificing our vital civil liberties, or upending the power balance between individuals on the one hand and companies and governments on the other. So there is a need of harmonizing, or you may say recognizing the harms of surveillance and crafting the laws pertaining to surveillance in such way which on the one hand uphold the civil liberties of the individuals, and on the other hand empowers the states to prosper, to regulate and to monitor, but to the extent that it does not intrude or transgress into the civil space or into the civil liberty space of the individuals. The concepts such as information assurance, information privacy, cyber security, cyber law and data protection are very integral to the present discussion which we are having right now, and they are the most important legal tools for control of electronic revolution. Well, as I said at the outset or in the beginning of this lecture, that it is not very easy or not so easier a task to have a balance between the civil liberties and the boon or bane of the electronic revolution. But there are a couple of normative frameworks, or there are a couple of laws or regulations which come handy, and they are integral to this aspect or this discussion topic of discussion today, which play a very crucial role, like information assurance, cyber law, cyber security, data protection, etc. The most important when it comes to electronic revolution and its legal control for upholding the civil liberties is the cyber law, to my understanding, because the data protection, information assurance, they also play important role, but the most important out of these is the cyber law, because cyber law is one such benchmark law in the country, or more popularly it as the information technology law, or set of law and some rules which basically pave the way for e-commerce, e-governance, e-banking, e-transactions, etc. in the country. Simultaneously, it looks after the cyber contraventions and cyber crimes as well, and the sweep of or scope of this law goes or does not remain restricted only to these elements, rather it goes beyond these elements, and it even addresses the concerns relating to confidentiality, data protection, intermediary liability, and so on and so forth. So, IT law or cyber law becomes the most important and relevant law. So, we may probably start discussing after having understood the challenges and issues the cyber law pertaining to electronic revolution and civil liberties. But let us have a look at some of the jotted issues and challenges in place. Well, while consumers can and do benefit from targeted product recommendations, they also can and do incur substantial monetary costs and disabilities from violations of their privacy in the cyberspace because of the electronic revolution. Then privacy invasive technologies have become integral to everyday communication, job searches and general consumption, which may also take away your privacy or your data. New search engines, social networks, e-commerce websites, web browsers and individuals, they control for privacy conscious consumers, and they these such engines which are smart and very advanced, these social platforms or networks which are very advanced, they compromise on privacy conscious consumers because they are very advanced, and because of their emergence, their advent, the consumer is at a great detriment. Social media services have facilitated a culture of disclosure and disclosure of one's activities, location, emotions, privacy, history, political opinions, etc. And it is seen that the liberty of opinion, the liberty of making criticism, review, has gone or has been diluted to a very great extent in the present times across the world, not only in our country or for that matter in other countries, but this is happening because we are judged by our political opinions. We used to have political opinions earlier also, when there was no social media or when there was no social platforms, but these days it has become it is very easier for discriminating somebody on the basis of, or being judgmental towards somebody on the basis of his or her political opinion as posted on a social media, or crimes can also be committed against the individuals because locations, their emotion, their history, etc. is available these days. So, anonymity is there, but on social media platforms, generally people don't prefer to be anonymous because they want to have a social circle, electronic social circle or virtual social circle, wherein their history, their likes, dislikes, their preferences, their family preferences, their consumer behavior, etc. is now known to everyone. So, lack of awareness and technical sophistication required to protect and regulate the multiple dimensions of personal information is also missing. People are digitally not literate, they are otherwise literate, but digital literacy is missing, and because of that digital illiteracy, they are not aware as to what should they post, what should they like or dislike on the platforms, or for that matter on any electronic sphere, or in the virtual space. So, there are many challenges so far as the civil liberties are concerned, and the reason for their they being at risk is the electronic revolution these days, or the impact of the electronic revolution. Earlier also, I mean prior to the electronic revolution, civil liberties were not that strengthened, but now the situation has deteriorated, and it has gone worst over the period of time because of the impact of the digital revolution or electronic revolution. And here lies the dilemma of legal control, because cyber law is one such law which addresses to some extent the proposes to some extent the legal control, but it does not actually cater to all approaches or all aspects of the electronic revolution or the impact of electronic revolution on the civil liberties. So, let us see where the cyber law fits well and where it does not fit well, and where is the requirement of some amendment or improvisation in the existing legal framework. Well, let me just explain you what does cyber law mean here. Well, cyber law basically includes legal, statutory and constitutional provisions which deal in computers and computer network. The computers and the computer networks are used by any individual, corporate bodies, and the problem can arise to anybody whosoever is using the computer or a computer network or a computer system. He or she falls under the ambit of the cyber law, or under the sweep of the cyber law. The cyber law applies to them only if corporate bodies, institutions or individuals enter into the cyberspace. They provide access to cyberspace, creates hardware or software which enable people to access cyberspace, use their computers to go online and enter into cyberspace. The litigants in cyber disputes maybe the telephone providers, software companies, computer training institutes, school, colleges, individuals, firms, and so on and so forth. Anybody may be the litigant of a cyberspace, or you may say of the cyber disputes. As I initially explained, that the cyber law or the IT law in the India is not restricted only to e-commerce or e-governance or e-banking. Rather, it goes beyond it, and it even covers or encompasses cyber contravention and cyber offences, or in more popular way you may say cyber offences, cyber crimes you may say. India is got this Information Technology Act in year 2000, and it is the first ever landmark cyber law which was brought or which was enacted in India in year 2000. It was enacted by the Parliament, and was administered by the Indian Computer Emergency Response Team, that is CERT-in, to guide Indian cyber security legislation, institute data protection policies and govern cyber crime. It also protect, as I said, e-governance, e-banking, e-commerce and private sector, among many other things. While India does not have an exclusive unitary cyber security law, it uses the IT Act and multiple other sector specific regulations to promote cyber security. Well, viewers, as I told you that India does not have a unitary IT law or one omnibus legislation to cater to the cyberspace. One popular law is the IT Act, but there are multiple other sector specific regulations to promote cyber security standards. It also provides a legal framework for critical information infrastructure in India. For example, in section 43 capital A of the IT Act, Indian businesses and organizations must have reasonable security practices and procedures to protect sensitive information from being compromised, damaged, exposed or misused. Similarly, there is another section called section 72A of the IT Act, and here under 72A, any intermediaries or persons that disclose personal data without the owner's consent are punishable by imprisonment up to 3 years, right, and fine may also be imposed up to 5 lakh rupees or both. So, there are a couple of other laws and regulations apart from the IT Act, and it does not only cater to one segment of the society, it encompasses intermediaries, it encompasses body corporates, and it encompasses individuals as well. The Information Technology Act year 2000 was amended in the year 2008, and it was made gender neutral, it was made technology neutral, it was made far more sweeping in comparison with the original law enacted in the year 2000. The most notable amendments of the year 2008 pertains to making the law more you may say more cohesive, especially by bringing a change by making it technology neutral, wherein not just one kind of a technology is covered by this, rather omnibus technologies are now covered or are being covered by the IT Act. Then further there are more changes which were brought, like more offences were included in the cyber in the cyber law or in the IT Act in year 2008, especially under section 66, where separate specific provisions like cyber terrorism under 66F, cyber voyeurism under 66C, etc. were brought, and the law was made more efficacious by bringing these changes. Then let me tell you a few more things about cyber law. As I tell you that the Information Technology Act was amended in year 2008, and it came into effect following a year as a substantial addition to the IT Act. These amendments helped improve the original bill, which originally failed to pave the way for further IT related developments. It was hailed as an innovative and long awaited step towards an improved cyber security framework in India. In 2008, the IT Act was updated and redefined for current use, expanding the definition of cyber crime and validation of electronic signatures. It also strongly encouraged companies to implement better data security practices and make them liable for data breaches. And as I explained that in year 2008, the Act was amended, it was applied to any individual, company or organization intermediaries that uses computer resources, computer networks or computer systems in India. It also included service providers of web hosting, internet, network and telecom. It also included foreign organizations that have a presence in India and businesses outside of the country that has operations in India. So, the cyber law is law which definitely is a territorial in nature, but even a foreign national may be made or subject of Information Technology Act of India if their operations are in India, or if they have accessed or used any computer resource, computer system or a computer network located in India for perpetrating a crime, for perpetrating some sort of a wrong or a tort. So, it is the beauty of this particular legislation that it does not remain confined to the territory of India. It even applies to the foreign nationals who use or who usually involve while committing the crime the devices located in India, or computer systems or networks located in India. So, our cyber law basically has 117 sections, and it has 9 chapters in it, right, and it includes the following responsibilities, or you may say that in its ambit there comes lot of responsibilities which it caters to or which it renders was first and foremost is improving cyber security measures, requiring intermediaries and body corporates to report to cyber security incidents to certain, preventing unauthorized unlawful use of a computer system, protecting private data and information from cyber terrorism, legal recognition for cyber security for organizations, safeguarding e-payments, electronic transactions and monitoring and decryption of electronic records, and establishing a legal framework for digital signatures, recognizing and regulating intermediaries. So, these are some of the agenda, or this is the agenda of the cyber law, or sweep of the cyber law, and it is if you look at it carefully, it is something which will uphold your civil liberty at the end of the day. It is something which will give you that constitutional right of expression, speech, freedom, liberty, dignity, right. It is something which will give you a right of professing any religion, or doing a trade or a business electronically or otherwise, right. So, in the context of the electronic businesses or electronic commerce, it is also necessary that every trader is free to trade, and there are no entry level barriers for a particular trader on the basis of sex, caste, race, religion, nationality, ethnicity, etc. And it is seen that e-commerce does not pose such hurdles, but when it comes to e-commerce, there is a unique kind of a hurdle which we confront, or end user confront, or as well as the end the vendor or the the e-commerce user confront, that is about predominance of certain entities in the market, and their anti-competitive behavior, their abuse of dominance, etc. We will discuss it in the end, that how the liberty pertaining to trade and commerce in the electronic medium is safeguarded by the competition law in India, by the competition mechanism in India, by the antitrust mechanism in India. Going ahead, we had had SPDI rules of year 2011 for reasonable security practices, which also upholds the or safeguards the civil liberties. These regulations are identified by the basically by the rules called SPDI rules of year 2001 as international standards. As such, Indian companies are not obligated but are highly advised to implement these standards, which can help meet the reasonable security practices under Indian jurisdiction. These rules can also give individuals the right to correct their information and impose restrictions on disclosure, data transfer and security measures. They only apply to corporate entities, but with the new act called Digital Data Protection Act of year 2023, individuals also fall in the ambit of these rules, or these security practices being followed. We have National Cyber Security Policy of year 2013, which also strives to uphold the human dignity as well as the civil liberty in the electronic space. The Department of Electronics and Information Technology, that is DET, released a National Cyber Security Policy as a security framework for public and private organizations to better protect themselves from cyber attacks. And when the cyber attacks are perpetrated, the end users remains the vulnerable section who is at the great detriment or loss at the end of the day. So, the DT's initiative in the form of cyber security policy is a welcome step to uphold the individual's interest in the cyber space. The goal behind the National Cyber Security Policy is to create and develop more dynamic policies to improve the protection of India's cyber ecosystem. The policy aims to create a workforce of over 5 lakh expert IT professionals over the following 5 years through skill development and training, and it has been done, and it has been achieved by the year of 2019. Following the agenda of the policy, or National Cyber Security Policy, and it has really helped to uphold your civil liberties to certain extent, or it has also contributed to become a good contributor of our ecosystem on cyberspace. Then we have IT rules of year 2021 declared by MITI, or brought by the Ministry of Electronics and Information Technology. These rules are basically very controversial, or have been very controversial. They repealed or replaced the previous IT rules of year 2011 pertaining to intermediaries. These rules aim to basically cater to users of digital platforms, and these rules also basically caters to intermediaries or the issues pertaining to intermediaries, or or holding the accountabilities of the intermediaries. These rules also distinguish between smaller and more significant social medias intermediaries, which is a unique unique initiative, or you may say which is a unique in these rules vis-a-vis to the previous rules, where there was no such distinction existed between the normal intermediary and a significant intermediary, or there was no such concept of social media intermediary or a significant social media intermediary. Well, in this lecture series we have a dedicated lecture on intermediary rules, as well as intermediary liabilities pertaining to intellectual property, or you may say pertaining to other aspects of the law. So, but for our better understanding at this juncture about the legal control mechanism pertaining to electronic revolution in the context of the civil liberties, it is imperative for me to discuss these rules briefly here, because these rules have brought lot many changes. There are changes like privacy and transparency requirements of intermediaries have been changed, such as requiring intermediaries to inform users about rules and regulations, their privacy policy, terms and conditions for usages of its services, etc., in a conspicuous manner. Prior to these rules, the intermediaries or these platform providers, or network providers used to have their terms and conditions, or their privacy policy, but they never made those policies conspicuous for the end users to comprehend and understand. But now these have been changed, and lot many changes have been brought, and it is obligated on these intermediaries to tell the rules and regulations and the privacy policy, etc., of the intermediaries. It also requires intermediaries to designate a grievance officer that can address and resolve user complaints about violation of these rules. And when it comes to a violation of a civil liberty, like freedom of speech or expression on a social media platform, the grievance officer is the recourse to whom you may represent, or to whom you may write about your issue. And it has been observed that prior to these rules there was no formal designated grievance officer on social media platforms, but now we have a dedicated grievance officer whose job is to address your concern. But it is also at the same time noticed and observed that these platforms at times maneuver these things, and they even go to the extent of suppressing, or discontinuing, or you may say dismissing one's account or one's profile from the social media platforms on the name of or under the guise of their rules and regulations. So the civil liberties again are at a great risk here in the electronic space or in the virtual space. But as I said that these rules have brought a change, because these rules require that any person's right, or any person's freedom of speech or expression cannot be curtailed even on these platforms whimsically. It requires or anyone's post or anyone's expression or its removal requires a formal court order, or order from a competent authority having the competent jurisdiction or having the adequate jurisdiction in this matter. Only then it can be, you may say, removed, otherwise it cannot be removed. When it comes to few more things or few more governing strategies in relation to electronic revolution, we have National Cyber Security Strategy of year 2020. This strategy of 2020 was a long awaited and it is a follow up plan by the Indian government to further improve cyber security efforts. While the plan is still under development and pending review by the National Security Council Secretariat, the plan's main goal is to serve as the official guidance for stakeholders, policy makers and corporate leaders to prevent cyber incidents, cyber terrorism, espionage in cyberspace. Well, this cyber terrorism has also been covered by 66F of the IT Act, or by the Information Technology Act. But let me tell you that espionage in cyberspace, cyber terrorism or cyber incidents, they are categorically the agenda of the National Cyber Security Strategy, because over the years we have seen that cyber terrorism has proliferated and a lot of misinformation or disinformation is spread electronically, right, in the name of freedom of speech and expression, which leads to communal riots or communal tensions, or even leads to mob lynching at times. So such strategy is going to be very significant step, or a very welcome step in order to curtail cyber terrorism, espionage or cyber incidents in the cyberspace. This strategy aims to improve cyber security audit quality, so organizations can conduct better reviews of their cyber security architecture, and it is hoped that once the policy is implemented, cyber auditors will improve their security standards, ultimately encouraging organizations to set up security programs. So it is also observed that a lot of laxities or a lot of shortcomings are there into the implementation of cyber security measures or security practices or standards in organizations. But with this National Cyber Security Strategy in place or in operation, the companies or every such organization which aims to have a security program or a standard, they will have to implement those standards necessarily. Then in the context of this issue of civil liberties and electronic revolution, understanding data privacy also becomes very important. You all know that data is new oil these days, and your data is the key for any business organization, any political party, or for any service providers, etc. And at the outset, I will say that protection of privacy cannot be separated from technological development, as nowadays the possibility to intrude into someone's privacy has increased due to development of science and technology. The law reacts to these changes, ensuring the legal protection of privacy. However, in order to ensure this protection, first of all, it is necessary to determine the subject of this protection, that is privacy, and what actually privacy is. Organizations manage large amount of customer data that could be in the form of customer expenditure, customer health data, project executed for customers, and so on and so forth. So this is also part of the civil liberty, that the customers or their privacy must not get compromised, their data must not get compromised, or it must not be processed or used in a unauthorized way. But you see the paradigm shift has come in the misuse of the data as well as in the processing of the data without the authorization of the data owner or the data principal, and data fiduciaries are rampantly violating the data of the data principals without even taking their consents, or without even informing them or bringing it into their knowledge. So this is something again is problematic when it comes to electronic revolution and civil liberties. And one of the legal mechanism which comes handy is the Digital Data Protection Act, in order to protect your data or your privacy. Then this data, as I said, is a strategic business asset, and it can be used to provide further services to the customer and build other marketing strategies. Corporations could use this asset for cross selling and sharing it with their business partners. The importance of this strategic business asset can be gauged from Goldfish ruling. So we all know that data is a new oil, and corporations does not confine using or misusing your data to themselves. They rather share it with their business partners, which further eventually use it for some other purposes, etc. So customer data essentially belongs to the customer, and the right to determine its use and disclosure belongs to the customer, but it is not happening because it is now not into the hands of the customer to have a control on his or her information. It goes away once you divulges it or you discloses it to in the virtual space to any of the network providers, to any of the platforms which you are using, or for that matter to e-commerce giants whom you are using for purchasing things, etc. So we have this act called Digital Data Protection Act, as I said, to cater to this categorically, and it is first ever privacy act to strike a balance between individual rights and an organization's legitimate data processing needs. The primary purpose of this act is to regulate processing of digital personal data and respect individuals' right to protect their data while recognizing the necessity of processing and using such data for lawful purposes. Well, this act has also carved limitations, or has carved exceptions wherein the government may use your data without even informing you, or may surveil on you. Your personal data can be used by the government in certain exigent situations, but this must remain up till the exigent situations. The problem will begin or commence when it does not remain up to that exigent situation, and when the government starts using your data for political campaigns or for other purposes. So that should not happen. The language employed in the act is simple and straightforward, ensuring easy comprehension for all. The act aims to establish a comprehensive legal framework to govern digital personal data protection in India. This act cover personal data in digital format, including both data that originate digitally and non-digital data that is subsequently digitized. So this is one important feature of this act, where it covers even non-digital data that is subsequently digitized. So any information that you fill in a form, that you provide to an educational institution on a paper, etc., even that gets covered under this act. The provisions of this act applies to data processing within and outside India. It relates to offering of goods or services to individual within India. The act recognizes both the rights of the individual to protect their personal data on the one hand, and the need to process such personal data for lawful purposes by the government or any incidental use thereto. The act also protects digital personal data by providing for the following: the obligation of fiduciaries, the rights and duties of principals, and financial penalties for breach of rights, duties and obligations. Well, this is something very interesting about this law, that this law even imposes a penalty for breach of the rights and duties and obligations of the data fiduciaries and data principals. Here the data principals are data owners, or earlier they used to be called as data subjects, but now they are given a reasonable name or reasonable terminology is used to address them, that is data principal. On the other hand, data fiduciaries are those corporations or companies or persons to whom you entrust in a fiduciary relationship your personal information, your personal data, etc. So if in case they violate it, or they tend to disclose it to somebody, or if they you may say don't follow the reasonable security practices, etc., as provided or prescribed by the law, then they shall be held liable, and penalties for breach of their rights and duties may be imposed on them. Moving ahead, this Digital Data Protection Act, which is one of the strong pillars of controlling electronic space or electronic revolution in context of the civil liberties, based on 7 principles, and these principles are as follows: the principle of lawful consent or transparent use of your data, the principle of limitation, that your data cannot be used for in an unfettered way. It has a purpose or it has a limited purpose in it, in the context of which it can be used. The principle of data minimization, which means that only very necessary or indispensable information is only stored or used or collected. No unnecessary information will be collected. The principle of data accuracy, ensuring data is correct and updated. Then the principle of storage limitation, that the storage has to be necessarily take place in India, or then it has to be specified, it has to be for a specified purpose. Then the principle of reasonable security safeguards, as explained earlier, and the principle of accountability, that in case of breach of any duty or right or obligation, the data fiduciary or the data principal will be held liable for any such breach or violation. Then we have a few other innovative features of this act, like this act is concise and it is thorough. When it comes to thorough, it means simple, accessible, rational and actionable law, as it uses plain language. It contains illustrations that make the meaning clear. It contains no provisos, and it has minimal cross referencing, unlike other laws prevailing in the India. So this is a simple, accessible, rational and actionable law, and which makes it an innovative law, or it gives it an innovative feature. Then by using the gender neutral terms like he and she interchangeably in this law. This law acknowledges other genders also in the law making. The act also provides for following rights to the individuals, that is the right to access information about personal data, the right to correction and right to be forgotten, right to grievance redressal, and so on and so forth. So for enforcing one's right, the affected data principal may approach the data fiduciary in the first instance under this law, and if he or she is not satisfied, he can complain against the data fiduciary to the Data Protection Board in a hassle-free manner. So these are the innovative features of this law, which makes it all encompassing, and which makes it very broad in sweep and its scope. Then there are certain exemptions, as I was telling you earlier, in the case of the government, in the interest of security, public order, sovereignty, statistical purposes, or for startups or other notified categories, or data fiduciaries may use for enforcing legal rights, for judicial and regulatory functions, and to prevent, detect, investigate or prosecute offences. Your data may be used under this act, because these fall under the exceptions under this act, and for approved merger, demerger, etc., and to locate defaulters and their financial assets. So one of the civil liberties that the exemptions here strive to ensure is the fact that in the cases of nation security or integrity or sovereignty, the data of any subject, or you may say the data of any data principal may be used by the government, which also is a significant aspect or a contributing factor for upholding the civil liberty in the society. Well, so far as the civil liberties are concerned, as I said, that civil liberties should be seen from the perspective of the individual as well as from the perspective of the nation state. When it comes to nation states, they constantly strive to code or ensure and enforce your civil liberties, and in that endeavor, in that constant endeavor, they require your information at times, and they require the information access to the information of unscrupulous entity and unscrupulous organizations. So that is why in the exigent situations, or you may say in the situations of some exigencies, the organization's data or the individual's data may be accessed or used by the government or by the data fiduciaries. Even the personal data may be used by the fiduciaries. Then as I was telling you, that competition law also plays a significant role in striking that harmony between the advent of electronic revolution and on the other hand civil liberties. When it comes to e-commerce specifically, it has been observed that in the e-commerce space or in the e-commerce domain, the new entrants are always discouraged by the predominant entrants in the market, and they try to always deter their entry to the market space, which is why the consumers of the particular relevant market stands at a great detriment or at a loss, because competition does not increase or competition does not lie in the market. So, for addressing such concerns in the e-commerce or in the electronic space pertaining to trade and commerce, the competition law plays a crucial role. The competition law specifically checks the abuse of dominance, and it also checks whether the dominant player is exercising or employing anti-competitive practices or entering into some sort of a collusion to stop others from competing, as well as the competition law here helps the data subject matter or the consumer protection laws or antitrust legislations are there to promote the e-commerce in the marketplace. Now, coming to the conclusion and the way forward, then I'll say that given that we have lot many laws and legal control mechanisms here, but this dilemma of having so many laws is definitely problematic. It must be straightforward, but it is not possible to have a straightforward legal control mechanism pertaining to particular the particular technology in question, that is electronic revolution, with respect to the civil liberties, because there are several manifestations of the you may say of the electronic revolution which are jeopardizing the civil liberties or promoting the civil liberties. So, democracies have to come up with the surveillance privacy balance. Digital surveillance oversight has to balance between an impetus executive that seeks to engage in power maximizing behavior and inquisitive public which is interested in preventing corruption, mismanagement and abuse. Skillful navigation of a more contested and dangerous online sphere by securing internet freedom against the rise of digital authoritarianism. The roles and responsibilities of government, civil society, internet providers and regulators will need to be reassessed and redesigned to ensure that they are adept at managing the complex, ambiguous and evolving realities that sit at the intersection of technology, politics and governance. So, you look at the last conclusion which perhaps is most concrete, that the governments have onerous responsibility to always confront the realities of the intersection of technology, politics and governance, and they must always strive and reassess and redesign their strategies to ensure the civil liberties to the civil society. With this I will conclude this lecture, and I am looking forward to meeting you with more interesting lectures in this series called Law, Science and Technology. Thank you very much for patient listening.